30 seconds. Again, green is go on your mic.
Are we ready?
Second, good.
Okay, let's call the meeting to order of the Supreme Court Nominating Commission. Do we have any business to come before us before we do our next interview?
An issue.
Yes.
In 2019, December of 2019, when the Kansas Judicial Branch was in the middle of a tussle with the Kansas legislature with regard to funding of the judicial branch, and it appeared that we were going absolutely nowhere. There were a total of 6 judges, 4 chief judges, including myself, 2 magistrates, and 1 AA banded together and hired the Rex Sharp firm out of Prairie Village to represent us. And we sued the Kansas legislature, both the House of Representatives and the Senate, on a mandamus and quo warranto action. We started working on that probably late summer or fall of 2019. Larkin Walsh was a member of that firm at the time and was intimately involved in helping us put the pleadings together with regard to that case. It was filed in December of 2019. And Justice Lukert issued an order probably within 30 to 60 days of the date of filing, dismissing that matter without prejudice, basically determining that it was premature and that they thought they would be better served to continue to negotiate with the legislature rather than war with them. That suit was never filed, or was never refiled. Obviously, since it was filed directly with the Supreme Court, there was no appeal that was ever taken. And that was the extent of my connection with Larkin, but I felt the need to make that disclosure since she actually worked for us. I've not had any contact with her since that case was dismissed. I don't believe I have a conflict, but I felt like I had the obligation to make that disclosure to the members of the commission and to the public at large, and I'm doing so now. And so I would like your input with regard to whether or not any of you view as having a conflict with regard to Ms. Walsh.
Do
you feel that you can evaluate her application and her candidacy without being biased based on your experiences with her?
I don't have any doubt about that at all.
So what's the sense of the commission?
Okay. Yeah.
Do you think that Mr. Frederick should continue deliberating on this?
Yes,
Yes.
we do.
Yes, I hear yes from everyone.
Yes.
Well, I don't think we need a motion. We'll just proceed.
Thank you very much.
And with that, we'll start with our first candidate of the day.
They didn't give me the. They didn't give me the government rate.
Oh. Good morning.
Good morning.
Fellow commissioners, it's my pleasure to introduce Larkin Walsh. Larkin is a 2004 graduate of KU Law School. She graduated in the top 12% of our class. As a 3L, she was the articles editor for the Kansas Journal of Law and Policy. Directly after law school, she went straight into what became 8 years of advising the judiciary at both the federal and state level. She was the clerk for Justice Beyer from 2005 until 2008. She later returned for a second term as Justice Beyer's clerk, but she also served as one of the 3 law clerks for Judge Murguia in the U.S. District Court. When she finished her clerking, she was employed by Sharp Law in Kansas City from 2017 to 2024, where she became a partner. For those of you who aren't familiar with this firm, it is a firm that is very well regarded. They handle complex civil litigation in state and federal courts. When Ms. Walsh was there, she did handle some appeals to the U.S. Court of Appeals in the Sixth Circuit. She handled complicated cases regarding federal discovery, Title IX claims. She handled an appeal to the 10th Circuit regarding a class action fairness under the Fairness Act. She also led technology initiatives at the firm. Ms. Walsh then returned to a previous employer, Stevie Siegel Hansen, where she has remained since 2024. She focuses on plaintiffs' rights in labor and employment. She also does antitrust, consumer protection litigation in state, federal, and appellate courts. Ms. Walsh, I'm going to ask you your first question. Several of the people who have worked with you, including judges, have described you as someone who has exceptional intellectual humility. So I want to ask you to define that. Do you agree that that is a special quality that you possess? And how would it contribute to the current Kansas Supreme Court?
Well, thank you for that question and the introduction. And also, just before I get started answering your question, I just wanted to thank all of you for, the work that you're doing here. It's incredibly important. And thanks for giving me the opportunity to come and visit with you. So intellectual humility, I actually wasn't familiar with this term until I read Judge Lieben's letter in support of me. And I found that to be so moving. And it really brings a tear to my eye that someone would describe me that way. I'm not a self-promoter. This is not my scene, but I do think that one critical attribute of being a good judge is to maintain that sense that, you don't have all the answers. It's about the process, and the process is really important, and fidelity to the law in that process, careful review of the facts, looking at the issues that the way that the parties have framed them when you're talking about an appellate court, and trying to get to the right result is what it's about. And so, ego doesn't play a huge role in that. And so I don't know if I've answered your question, but that's why I love the term. I love that someone said it about me, and I do think it's an important quality for a judge.
Thank you. So I talked a little bit in your introduction about your significant legal experience and your education, obviously. But can you tell the commission about your work with the Kansas Survey of the Law, which I think is when you started working with Judge Lieben, what that project was and how you contributed to it?
Sure. So the Kansas Bar Association puts together this publication that is an annual survey of law, and it's really collecting updates over the course of the year from practitioners in specific areas. I think the survey covers maybe 30 or 32 specific practice areas. And I got involved when I first started working for Justice Breyer on the Kansas Supreme Court because Judge Green E, as we called him, Judge Greene, was the chair of a committee for the KBA and got to know me and got me involved in editing the articles as they would come in. And I just kept working on that project. Since 2005, I've been involved in that committee and, ultimately served as co-chair with Judge Lieben. And I think it's an important project because if it's working as designed, it's sending to practitioners across the state like all the updates of what's gone on in their area of law over the course of the year. And certainly when we started, maybe not so much now when people have easy access to what's, what the updates are. It certainly, I think, is an important resource for folks to use. And so I've been honored to be part of that. And it's just sort of been one of the many things that I feel like I'm giving back something to the bar and to that community. So I hope I answered your question on that.
You have. And so you said you've been involved in that project since 2005 and it goes out every year, roughly 30 areas of law. And that requires you to help edit, organize, find authors, make sure it goes out as a high quality product.
And while I was co-chair, I will say Judge Lieben kind of took the author part and I kind of took the editor part. So I worked more closely with our team of editors, which are a board of editors that, people cycle out of it. But it has included a really incredible group of talented professionals. So I've enjoyed working with them.
I think there's that intellectual humility we were talking about, but yes, I'm sure the editors helped as well. Tell us also about your opinion on, a lot of the people that I've spoken with who worked for you talked about your ability to collaborate among groups of, typically lawyers, sometimes with very different personalities and different opinions in a way that really seemed to, people described it almost as like magically reaching consensus and helping people feel heard. Can you describe some examples of when you've had to do that and how you see that contributing to the court?
Absolutely. I do think it's important, and it is my nature to kind of want to gather all the information, to listen to people, to listen to the different sides. In my practice, we're rarely acting alone. We're typically co-counseling with someone, with a firm. And in the multi-district litigation that I'm involved in, which, really combines cases that are filed across the country potentially, that are all, on behalf of the same groups of people against the same parties with the same claims, and the federal courts consolidate them all in one place, and all of those attorneys have to work together. It's like hundreds of attorneys sometimes. And when we're in leadership in multi-district litigation or MDL, that's a real job. And, what I have found is that being the loudest or being the most inflexible or being the most aggressive is never the most effective. And my approach has been, and I think this is true, if you have a focus on like what the issue is, what the objective is, what the rules or law are that apply, then you can work toward the right goal, and get there. I will also say that in addition to working with hundreds of attorneys day in and day out, I have 4 kids. So like managing personalities and trying to build consensus is like a full-time job, eat, sleep, breathe for me. And I know that, finding consensus where it's possible with the 6 other members of the Supreme Court would be a joy.
Well, this is my last question, then I'll open it up. I'm sure you've reviewed the list of other applicants. We have some incredible, brilliant minds applying. Why do you think you're the most qualified candidate for this position?
Well, I did give some thought to what might set me apart, because you do have a list of like highly qualified candidates. I don't envy you having to choose 3 of them to send to the governor. But I think what sets me apart is my significant practice experience as an advocate. As an advocate, I've represented people. I've represented people. My work is focused on civil rights, workers' rights, consumer protection, and it has taken me, from representing farmers and royalty owners in the 26th Judicial District, which is like southwest as you can get in Kansas, ensuring that oil and gas companies are cutting square corners with them and not shortchanging them under their leases. And I've represented, like satellite installation technicians in cases across the country who've been misclassified as independent contractors so that their employer could avoid paying them the significant amount of overtime that they're owed. I've represented folks who've been the victims of price gouging by pharmaceutical manufacturers in the EpiPen MDL, which was here in the District of Kansas. And, my daughter is a class member in that case. We're an EpiPen family. I just think this collection of experiences, and I'll also say, a great deal of the experience has been in the appellate courts. I've sort of been the go-to, because of my prior, experience with the court. I've been the go-to kind of appellate attorney in the law firms that I've worked in. And that has had me arguing and briefing in front of the Kansas Court of Appeals, petitions for review to the Kansas Supreme Court, briefing and arguing in several of the United States Circuit Courts of Appeal, and even briefing to the United States Supreme Court. And I think all of that practical experience has given me a really clear perspective and understanding of the importance of access to justice and the importance of a fundamentally fair process. I represent people. I understand the litigants. I understand the claims, and I understand what's at stake. And so I think that gives me a unique perspective and a perspective that might round out the current court and would be valuable. I also think that my experience clerking at the Kansas Supreme Court sets me apart. I mean, I've been here. I don't know that there are any other applicants who can say that exactly. I started my legal career here, clerking for Justice Breyer. And in doing that, I was involved in the small group dynamic. I took apart the records. I did the legal analysis. I drafted pre-hearing memos for the court, prepared questions for argument, assisted in drafting opinions. And so I have a I have a really high comfort level with what the job requires. So I do think that sets me apart. And altogether, well, relatedly, my experience at the federal district court, which is a trial court, really kind of gave me a clear insight into the differences between an appellate court and a trial court. So the roles of the judge in those courts are very different roles and require different skill sets. At a trial court, your judge is making findings of fact and credibility determinations. And an appellate court judge needs to apply a higher level of legal analysis, to create lasting precedent. A trial court judge is, necessarily exercises a great deal of discretion in managing their courtroom. An appellate court judge, by necessity, does not. Even the fact of an appeal is statutorily prescribed. So I think that experience at the federal district court, trial court, kind of gave me that insight into the differences between the courts. And also, as a practical matter, all of my 20 years of experience have kind of instilled in me the importance of the standard of review that applies to trial court decisions when they're on appeal, and the importance of, truly, I say, access to justice. It is access to justice and a fair process, and consistency in application of the law. And so altogether, I think that those qualities and my experience combined are reasons why I am qualified to serve.
Thank you.
Other questions?
Yeah, you just mentioned, consistency of the law. I'm curious if you could just tell us a little bit about your judicial philosophy. And, as an advocate, I'm certain you look for applying creativity in your practice, but is there room for that as a judge?
Judicial philosophy and creativity in the law.
Yeah, how do you look at the application of creativity in the law?
I will start with your first question. I think the judicial philosophy, what we need and expect in a judge is that they will consider the facts impartially, objectively, and apply the law to those facts impartially and objectively. And that sort of faithfulness to the rule of law is critical to the fundamental judicial philosophy, right? As far as creativity, I certainly see that as an advocate being a really strong quality. And I think as a judge, it's a difficult question to answer, particularly as an appellate judge. If you looked at my resume, my background is in the arts, and being creative is something that is innate to me. I value that part of my personality and my approach, because I do think it enables me to, build consensus, find points of agreement, maybe thinking about things in a different way or describing things in a different way that can help people see, a different perspective. I do see a place for creativity in the judiciary, but ultimately you're working within a very prescribed, set of rules and laws. But I know, as the court of last resort, sometimes creativity is important in reaching a result.
Thank you.
I've got a couple questions. You've got a lot of experience in different things. What part of your experience that you've had so far do you think best qualifies you, or was the best experience you've had in order to change from private practice where you're in now to being a Supreme Court justice for the state of Kansas?
So your question, if I understand, is like navigating the transition from being an advocate to being a judge.
Yes, and what experience that you've had in the past you think has best prepared you to be a justice of the Kansas Supreme Court?
Thank you for that question. I think that's a good question. I think my answer to that question is that working for the judiciary, you know, on that side of the bench for 8 years is what has prepared me to succeed in that role. And I actually found it really challenging to move from an objective approach to thinking and writing to an advocate role. And I think that my experience clerking at the courts has made me a better advocate. I do think that lawyers are best served, and they best serve their clients when they can state the facts objectively, when they deal with the weaknesses in their arguments, you know, when they don't ignore but distinguish cases that might go against them, and not ignore them or gloss over them. And I think it's important and an effective trait for an advocate to not sensationalize, not use hyperbole. So I think that a transition back to the court will be a very natural one for me, particularly in terms of writing. And I think that my experience has prepared me for that.
And so, your civil experience that you've had with the Sharp Law Firm and your current firm, that appeared to me from the descriptions in your application to be almost entirely on the plaintiff side, if you will. And have you had any experience on the other side? Some people call it the dark side, but for the defendants, have you ever had any experience in that side defending somebody who's been accused of wrongdoing or violating somebody's rights or injured somebody?
So my experience as an advocate really has been on behalf of people. And in moving from a clerkship into private practice, I really had like a soft transition to Stevie Siegel, which is where I am now. A soft transition because I was research and writing focused. No, it's true. My practice experience has been in representing people and call that plaintiff side work.
Well, were any of those people defendants, or were any of them sued by somebody who said they did wrong? Or
I can think of one example where we represented the defendants in a case that was a result of having been plaintiffs in a case where the insurers of the defendant filed declaratory judgment actions concerning coverage against our clients. You know, I have to say that my experience, and this is purposefully, you know, I was never drawn to work at a defense firm representing, you know, companies, businesses, organizations. Like I've always sort of been drawn to representing people, and some part of me that is really committed to public service feels satisfied by that experience.
so, and based on your experience representing people primarily on the plaintiff side, will you, if you're a Supreme Court justice, tell us how you'll be able to set maybe those advocacy views aside to make sure that you are giving everyone, whether they're a plaintiff or a defendant, a prosecutor or a public defender, an even playing field. Just talk a little bit about that.
Absolutely. I do think that's number one priority. And that's an access to justice issue, you know, and impartial application of the law. I don't consider the idea of moving into an appellate court position as a member of the Kansas Supreme Court to be at odds in any way with the practice experience I've had. You know, I've been fortunate to represent folks who've suffered an injury that the law creates a remedy for. And you know, as an attorney, as an advocate, you win some and you lose some, and you expect that, you know. But the important thing is that your client was heard and that your client got a fair shake, you know. So as an advocate, you know, that having that level playing field is critically important. And I would certainly take that commitment to the bench. I can provide you an example. And I didn't include this case among the cases that I talked about in my application, although it is also a significant case to me. You know, in my experience as an advocate and behind the bench, I think, you know, we want everyone to have a fair shake. That's sort of the foundational part of the process. And it's been my experience that is true, win or lose. You know, you've had that opportunity in our judicial system. I have had one experience where that was not the case, where, you know, the clients we were representing who were labor trafficked from the Philippines did not get a fair shake, did not get correct application of the law, and had no recourse. And you know, that case kind of haunts me. It was a challenge to deal with the reality of that situation with those clients. And you know, and also personally, the idea that I played a part in a particular decision now that's out there, you know, has precedent potentially for other folks, and had no way to correct it. And so taking from that experience, I think the most critical piece of our justice system is fair and impartial administration of the law in the tiered system that we have, and that, you know, that I've been a part of that as an advocate, and I respect that, have a great deal of respect for that, and would expect that to be my approach to judging as well.
Thank you.
Ms. Walsh.
Yes. Oh, go ahead. We'll start here and we'll
From
come over.
your application, it would appear that you probably had little, if nothing, to do with the criminal arena since probably you left the court. And I'm wondering whether or not that absence of experience is viewed by you as any kind of a weakness.
Thank you for your question, Judge. I think there is more I've had more criminal experience that might meet the eye. Yes, as a civil litigator and as an advocate for the last dozen years, I've been a civil litigator, been doing civil cases. But in the most recent, maybe 6 or 7 years, the cases that I'm focused on actually arise out of the criminal code, primarily under the Federal Trafficking Victims Protection Act. So although these are civil cases, we're representing victims of crimes and folks who've been victims not only of crimes, but of institutional failures, like systemic failures that permitted or facilitated those crimes to happen. And while there's still a civil, burden of proof, and there is a criminal element to these cases, and we're required to prove the underlying elements of the crime. But I think the best answer to your question is, in my 8 years of clerking experience, which is a significant amount of clerking experience, I would say more than 50% of the work at the Kansas Supreme Court involved criminal cases and complex criminal cases. I remember when now Justice Wall was special projects attorney, working on some really, really interesting, difficult, and complex criminal cases. And in my experience at the federal district court, a trial court, it's more than 50% criminal work. The criminal cases take precedent over the civil cases because of the Speedy Trial Act. So most of the work we were doing was on criminal cases, every aspect of it, from arraignment to motions to suppress to trial. My first week on the job, I was the clerk assigned to this 6-week-long multi-defendant criminal trial, and that was a sink or swim. And I found those cases, the criminal cases, to be among the most interesting cases that we worked on. There's more at stake. It's someone's liberty at stake. And so I guess in trying to shorten my answer to your question, I do feel like I have experience on the criminal side, and that will serve me well in the role.
Do you have a philosophy with regard to constitutional interpretation?
Constitutional interpretation. I think the answer is no. I don't have a particular philosophy in regard to constitutional interpretation. I do view the members of the court as, the last resort safeguard of the guarantees that are set forth in that document, and that they're protectors and interpreters of those rights that we, the people, set out, for ourselves. So I suppose the philosophy is one of approaching that with a great deal of respect, approaching case law, interpreting the Constitution with a great deal of respect, and I don't think I have a particular judicial philosophy. If you're thinking of contextualism, I think an exercise of restraint is important. I think closely reasoned decisions are important when you're dealing with constitutional issues in particular. So I suppose that's the best answer I can give to your question.
Thank you very much.
Carol?
In talking with the justices, they say about at least 60% of their time is spent administratively. Can you describe your administrative skill set and experience?
Yes, I do know that a good deal of the justices' time is spent on administrative matters, and they're important matters. They have an entire state court system to oversee and make sure runs. My experience in law practice, is a smaller scale, but in a small shop, we started out at Sharp Law with four people. They're doing everything, which not only includes, writing the briefs for the court, but making sure the FedEx packages go out and that the trash is, all of the work that goes into managing a business personnel issues and hiring decisions. And Katie mentioned putting on, interviewing vendors for an ESI platform. We have a big case with a lot of data coming in. So I think that experience, like I recognize that a good deal of any job is administrative. And I'm familiar with the administrative work that the justices have to do. When I was clerking for Justice Beyer, a great deal of her time was spent liaising with the boards that she was assigned to, including the Board of Law Examiners, which is a board that I served on for 10 years. And that board does incredibly important work. Like all of that administrative work is critical to the functioning of the courts. And I think that the administrative duties are, and I would like to think of them as an opportunity for the justices, an opportunity to do some of that civic engagement, one-on-one engagement with folks who have a stake in the institution. So I think my experience both at the court and in law practice in a small firm kind of set me up to take on those roles, and I would view them as an opportunity.
Any other questions? Well, thank you, Ms. Larkin, and appreciate your being here.
Thank you. I appreciate all your work, and I don't envy you your task. Thank you for having me.
Thank you.
Thank you. Thank you so much.
Yes, we'll just go a little long.
Hi, good morning.
Good morning.
Good morning.
Can you guys hear me okay?
Yeah.
Well, it is my pleasure to introduce to you Judge Robert Winnell. He is a judge in the 10th Judicial District, Johnson County. He graduated from KU Law in 2001, and at that time went into private practice in Kansas City. 10 years ago, he was appointed to the bench in Johnson County, and he's here before us today. So, Judge, I'd like to start with a few questions. Can you tell us about yourself and what led you to apply for this position on the court?
Well, sure. I'm a fifth generation Kansan. I grew up in Jefferson County, went to law school in Douglas County. was based out of Wyandotte County for my entire professional practice. And then for over a decade now, I've been sitting on the bench in Johnson County. I put in for this job because I love what I get to do now as a judge in the judicial branch. I love the state of Kansas. And growing up, people would ask me what I wanted to be, and I said I wanted to be the governor. And I'm kind of in the wrong branch for that. But I, for a variety of reasons, when this spot became open, I decided it was time to put in. It was clear.
Well, Judge, can you tell us a bit about your current docket assignments and give us a sense of what your workload is like in the 10th?
Sure. When I was appointed to the bench, I was assigned Johnson County as many judges. So we have a little bit more specialized dockets than you would see in other counties in Kansas. And when I was appointed, I was immediately assigned to a family law docket. I held that for about 4.5 years. And then I switched to a full civil docket. So I have predominantly a full civil docket. Basically, if it's not criminal or family, civil's just about everything else except probate. I attended a regional summit with now Chief Justice Lukert and some other members in Deadwood, South Dakota, addressing the issue of behavioral health in the justice system. And when I came back, I wanted to find a way to have more involvement with that particular docket. So I asked our probate judge if I could take over the civil commitment, or what we call care and treatment cases here in Kansas. So at the time, I took that over. It was roughly 250 cases. It's grown since 2019. Last year, we had over 600 filings. So I preside over our care and treatment docket in addition to my general civil docket. I also preside over 2 specialty courts, an assisted outpatient treatment docket, which is outpatient oversight of civil commitment upon release from the state hospital. And I also preside over a criminal behavioral health court. So that's the current structure of my docket.
And Judge, with respect to care and treatment courts and mental health issues within the judiciary, you've played a broader role within the judicial branch in promoting these kinds of services to the people of Kansas, and have been involved in the mental health summit that occurred in 2022 and another that is getting ready to happen, I think, later this summer.
In August.
Can you tell us more about your work statewide and what that's meant to you?
Sure. I think the 2022 Mental Health Summit was a significant event. We had over 500 participants. That was a combination of in-person and online. Our opening was given by Governor Kelly, Speaker Reichman, Senate President Masterson, and Chief Justice Lukert. And it was really an amazing day and a half. And we designed it as a team, and it's more than just me. We had a team to be a catalyst for the state of Kansas. And we really think that it has been. Out of the Mental Health Summit, we established a state delegation, what we call multi-branch community of practice. And it has representatives from all 3 branches. And we meet, and we're also concurrently now planning the 2025 summit. But what the multi-branch community of practices are designed to do, because we wanted it to be statewide, is for every judicial district in the state to have a group. And at its essence, what it is a convening of stakeholders. So anyone that might be somewhere at the intersection of behavioral health and the justice system, from judges to attorneys, law enforcement, faith communities, individuals with lived experience, mental health providers, bringing everyone together to basically say, what are our issues and what can we talk about from a multi-branch perspective to make progress in these issues? It's designed so that it's a conduit of communication from the local districts to the statewide delegation, so that at the highest level, all 3 branches can be reviewing requests. I'm happy to say that as of today, we have 26 of the 31 judicial districts across the state that either have an up and running group or are in the process of beginning that group. And really excited about that. Still have a couple of months left to try to make it 31 out of 31, but it's significant. And where we're going to go from here is even more exciting. I think if you look at the outcome of House Bill 2353, just the idea of all three branches coming together is an exciting catalyst prompt for what can really happen across the state. And that was a bill that passed unanimously in our legislature. And it's really exciting for the potential of what could come.
Judge, if you were appointed to the court, would you envision continuing that work?
Absolutely. I mean, when you look at our current Supreme Court justices and the various administrative roles that they have, Justice Standrich with the Child Welfare Summit, Justice Wall with the Rural Justice Initiative, we see these particular initiatives. And absolutely, we have a behavioral health coordinator, we have a specialty court manager, and really not just those roles in the multi-branch community of practice with Chief Justice Lukert serves on now, but also the role of specialty courts across the state. They are continuing to expand. They are a wonderful service to the public and really kind of a statewide perspective, organization, and communication is something that I would truly enjoy being involved with.
Thank you. I want to switch gears a little bit, and come back to more traditional legal work.
Okay.
Supreme Court justices, as you know, are required to produce high quality, well-reasoned written opinions. Can you describe the research and writing that you do in your current role and how you might approach those tasks as a justice on the court?
Absolutely. I think briefly, when it comes to legal research and writing, I'll start with my time as a practitioner. As a practitioner, I appeared in front of the Court of Appeals for Kansas, Missouri, Oklahoma, and Nebraska, as well as the 10th Circuit. And I'm aware of the work that goes into preparing, arguing, and writing. When I became a judge, there was less writing on, on the family docket, although there was some. Obviously, that role has expanded with the civil docket. We have a research assistant that helps a variety of judges, and that is a resource that we have. But ultimately, writing is an extremely important part of a district court judge role. It's part of many duties that a district court judge has. One that I take very seriously, one that I devote time to. Always would love to have more time to devote to truly excellent writing, which I'm convinced is the product of spending time in it. And I think to answer the final part of your question as it relates to a Supreme Court justice, I think it's one of the parts of the primary role of a Supreme Court justice when it comes to participating in every opinion, but also authoring many of them. And it needs to be excellent. It needs to be clear for both the practitioner as well as for the general public. And I think it's an extremely important role that I would welcome the opportunity to be able to devote significant time to producing excellent writing.
Thank you, Judge. Everyone comes to the court with a unique background and a worldview that's informed by their life experience. So can you tell us, either in practice or thinking towards the future, how do you separate your personal views from your duty to apply the law fairly and impartially in each case that comes before you? For example, how would you respond if you were required to apply a law that you didn't agree with?
Well, I will tell you, and as this is a public meeting, I won't violate the canons of judicial ethics and say which one, but I can generically say that I've done that. I've applied a law that I did not agree with, but that's my job. And that's what we want our justices to do. The role isn't what does this particular person personally think, and we don't want that. No matter what your personal belief is, you don't want a judge who does that. You want a judge or a justice that understands their role, understands the separation of powers, understands the application of the Constitution to the case and controversy in front of him or her. And so for me, because I hold the position with so much esteem and respect, it's really not difficult, because that's not what any cans and wants or deserves, is just a judge doing what they think is best. It's what is the Constitution, what is their role. And so knowing that and appreciating that, I think has made it a lot easier to apply it in my daily work.
I have one more question for you, Judge, and then I'll open it up to the other members of the commission. As you reflect over your career, either in practice or while on the bench, can you share any mistakes that you have made? And if so, what you've learned from
How much time do we have?
them?
So I'll try to share two briefly. And I want to be transparent with this commission so that you know exactly what you're considering. Early on in my first couple of years on the bench, there was a lot of training and focus on implicit bias. And in being transparent with you, I will tell you that I attended that, I listened to it, and in my heart of hearts, I thought, that's really not me. I don't have implicit bias. I treat everyone without bias. Everyone is created equal and is fair before me. And then one day, at the end of a family docket, I had just determined a parenting plan for a particular case. And one of the attorneys stood up and said, okay, Judge, that's fine. We understand that, but we need to make sure that it's consistent with the protection from abuse order that was recently entered. And I said, okay. And so I said to that attorney, and his client happened to be the wife of the domestic dispute. And I said, okay, let's deal with it. When did you get the protection order? And the father immediately said, excuse me, Judge, I'm the one that has the protection order against her. And I will never forget that moment, because it didn't change the application of what I needed to do, and it didn't change the substance of what I needed to do. But I have wondered to this day what that gentleman left when he thought. And my first question was, when did you get the protection from abuse order, when in fact she wasn't the one that had obtained it? So that very quickly humbled me and changed my view on that particular issue. I will also share, attempting to share briefly, I sat with the Court of Appeals by invitation in 2020, and it was an amazing experience. It was April of 2020, so it was shortly after the start of the pandemic, and we were doing everything remotely, and we were assigned some decisions to write. And there was one particular decision that we all agreed on an outcome, but they asked me to write the opinion, and it just happened to be an opinion with lots of, it was a DUI case. The name of the institution had a very Western name. Some of the streets had a Western name. And I remember the presiding judge saying, you know, that might be something that you could have a little more creativity with in your opinion. And I didn't really know what that meant. So I wrote one, and it read more like a novel than it did a judicial opinion. And as I was writing, and I thought, is this respectful? Is this what the opinion should be? So I sent it to the presiding judge, and I said, I think we should have Chief Judge Arnoldberger take a look at this before we sent the draft opinion. And Judge Arnoldberger looked at it, and she agreed. She said we wouldn't want this to be interpreted as an attempt to be funny or anything like that. And so I appreciated that insight. Obviously rewrote it to be a more traditional, if you want, appropriate opinion. But even though that was not a published opinion and no one's ever seen that, to me, that experience of writing that appellate opinion really reminded me that every single case I will be doing will be in relation to a particular individual, and that individual deserves the complete respect, even if I don't rule in their favor, deserves the complete respect of the court. So I learned from those mistakes. We could stop that question now.
Fair enough.
Judge, thank you for being here. You mentioned in a previous response that the specialty courts are a wonderful service to the public. Just wondering, you know, the broader public, do they view the specialty courts or know about them? And I'd love to hear your thoughts on the importance of educating and building public and community support and understanding, broader understanding of the judiciary. And so how would you tackle this? And are you doing this in your current role?
I think many individuals in the public know generally about specialty courts, and I think that knowledge is growing. I don't think it's anywhere near where it needs to be. I was actually at a national conference 2 weeks ago and went to a session on this particular topic about the ideas that I hadn't thought of, about 5Ks and managing your social media pages. And I don't have a social media page. And so just understanding about the ability to communicate with the public what we're doing, because not just the data that we have, and the data is there. The data is there on how specialty courts work, no matter what specialty court you are associated with. But the public should know not only that that is a healthy functioning part of the judiciary, but also as a potential resource. House Bill 2353, for the first time in the state of Kansas, we now have step-up outpatient treatment order possibilities across the state. And I won't get into the details of that other than to say the public needs to know that that's there if they are in a situation where they're wondering how to get help for a loved one. So it's not just educating about what's happening, but educating about what resources are there. We try to make our specialty court as open as possible. We have had many visitors. We had over 15 states that have viewed our assisted outpatient treatment docket, whether in person or online. So we engage with other judges, we share ideas. I'm working right now on trying to figure out how to even more promote what these courts are doing. There was a court in Oklahoma that got together to pack back snacks for the local schools, just things like that that are absolutely allowed within the canons of judicial ethics and part of the ethic as it relates to promoting confidence in the judiciary. So I think we've started, Commissioner Clemens, but we've got a long way to go.
Wonderful, thank you.
Go
ahead.
Sorry. No, go ahead, Ebony.
Well, I was just curious, you mentioned the creativity in your writing for that judgment. So I'm curious as to your thoughts do you believe that the Kansas Constitution is dynamic or do you think it's static? And is it?
I think it's a case-by-case situation, and I'm going to explain my answer. I think Justice Keegan said that we're all textualists, and I understand what she meant by that as we start with the Constitution as this original document that we need to apply the certain facts of the case to it. And obviously there's the spectrum of, is it a living document or a document to live by? And I think you have to look at everything on a case-by-case basis, because when you get into the Constitution, it has certain terms that, as they're written, require some type of external analysis. We are, under the Fourth Amendment, not to have unreasonable searches and seizures. We're not to have excessive bails. And so when you look at those adjectives of excessive and unreasonable, there has to be some kind of context. Seventh Amendment, if the controversy exceeds $20. So I think everyone, especially a Supreme Court justice, when they view the Constitution, has to start from the position of, what does the document say? What is the Constitution? And look at the facts and apply that to it. When necessary for that particular case, look at an external type of application or rationale. But I think your starting point has to be static or textualism, understanding that you're going to have to expand from that from time to time.
Thank you so much.
All right, Judge. I think that your description of the interbranch work that you've been doing is really interesting. I'd like to hear your thoughts on how you would bring that to the Supreme Court. I also want to hear, I think anyone who's practiced in Johnson County, as well as your esteemed colleagues on the court, would agree you're the funniest judge. There's no doubt. And I want to hear you talk about your collaborations with the interbranch groups and your collaborations with the other judges, what you would bring to the Supreme Court in all of its, you know, the administrative side, the legal side, and how you would contribute.
I think multi-branch work is one of the greatest joys of my professional career, was introducing those four individuals that I listed earlier. Individuals from different political parties who were on the stage saying the same thing as it relates to Kansas. And I think that we can continue to do that. I will share a very brief story of encouragement. When we were planning that summit from a multi-branch effort, Representative Brenda Landwehr was in charge of the Mental Health Modernization Committee for the legislature. And she said to Justice Luker in the middle of the meeting, I've been running this committee and I have no representation from the judicial branch. And she just said, that's not something that should be. And she said, Justice Luker, can I have 3 individuals? And that's just a small picture of just the legislative branch recognizing there's a lot of value that not just the judicial branch, but the executive branch can provide to what we're trying to do. Understanding at the same time, absolutely, the separation of powers. So for the judicial branch to have representatives on that particular committee, and I was one of them, to be able to advise, to answer questions, to let the committee know what was happening in the courts, but to ultimately submit to the authority of the legislature to what they were going to do with it. But I don't think you get there without that conversation. I don't think you get there without that invitation to work together. And that's what I really like about the multi-branch community of practices, because they are all three branches. The last part of your question is, what would I do if I were on the Supreme Court? I would do what I have been doing, only on a larger spectrum. I've attempted to do things for statewide benefit, but as a Supreme Court justice, I would continue those efforts of being available, of initiating conversations, of making sure that we understand the issue. We're not going to agree, but making sure that we're the most informed with the most perspectives. I hate to keep going back to House Bill 2353, but I think it's an extreme encouragement for that issue. It died without hearing. We met for a year, for 12 months. We met and we talked about it. What were the objections? What were the problems? We described it. And it was an extension of the Care and Treatment Act. So there were questions about protection of constitutional freedoms. And we met for a year, and it was reintroduced. It passed the House and the Senate unanimously. And I think it was just a product of all three branches coming together and talking through the issue. So absolutely, I would continue to do that if I were appointed to the court.
I have a quick question. You spent a number of years with the MVP law firm.
Yes.
What type of cases did you handle when you were with?
So when I first got hired, I started with workers' compensation cases. And I will tell you, when I first started there, that wasn't exactly coming from law school or writing for the Kansas Journal of Law and Public Policy what I thought I would be doing, but I'm really glad I did. And the reason is twofold. Number one, I traveled all across the state of Kansas, which I loved, but also I had a lot of just right at the beginning of my legal career, taking depositions. It was administrative law judges, but appearing in front of judges and getting that perspective and that experience. I then transitioned to really half and half of my practice. Half was representing employers in employment actions, representing a lot of municipalities, unified government, BPU, as well as private employers. And then the other half was just more of a general litigation defense, a lot of insurance defense type situations, whether it was slip and fall. I didn't do a lot of auto, did a little bit of attorney malpractice, but it was about half employment defense and advising employers on policies and procedures, and then half just kind of a general litigation defense.
I have a quick question. It has nothing to do with your legal background, but with your community involvement.
Sure.
Can you tell us a little bit about the water projects in Ethiopia? And my real question is, did you truly go a year and only drink water?
I did. My wife and I were talking the Thanksgiving before about what we could do. And there was, discussion about, well, don't drink coffee for a week or something like that. And I said, what if, which always makes her a little nervous. I said, what if I didn't drink anything but water for a whole year? No coffee, no tea, no soda, but not just that, which would be great for health, but talk to people about why I was doing it. So I did. I ran a marathon and I got pledges per mile. I spoke at civic groups. I had opposing counsel make donations to the event, and we raised $12,000. And what was really exciting was once we did that, Living Water International, I didn't bring them, but I have 2 pictures from the actual wells that were built in Ethiopia, and to just see the community come around. I was advised of the issue of the lack of clean water globally, and I wanted to do something about it. And it was an amazing year just having those conversations. And so thanks for asking, because it was 2013. It was a while ago, but it was great. I really enjoyed it. And yes, only water. I have to say I drank only water though, because if I say I only had water for a year, people think I didn't eat for a year. And that's not the case.
Well, it sounds wonderful. Thank you.
Yeah, thanks.
Your Honor,
Yes.
we've got 15 qualified candidates. Do you have a sense of what it might be that separates you from the balance of the field?
While I know some of the candidates, I don't know the information that you have. I don't know to the full extent of those 15 candidates. So I can't really speak about them, but I can tell you my heart. I have a passion for justice. I have a passion that everyone is treated equally. I have a passion that we work to make sure that everyone has access to justice, even those who society may have only viewed as existing on the periphery or within the margins, that everyone has an access to justice. I love what I get to do every day. I can't believe I get to do it. I don't know that the other 14 applicants don't possess that, but I know that I do. And in addition to really loving justice and being grateful that I get to work in that field, I also love the state of Kansas and the idea of working to advance and promote justice across this state. I can't say that there's another candidate that is less than that drive for me, but I can say I don't know that there's one that has more.
Thank you.
That sounds like a good time to say thank you.
Oh, okay. Time flies. It really does.
Is there anything else you want to say before we?
I just want to say thank you for the last month, for the last day and a half, for the work that you've put in. You all know a lot about the 15 of us. I suspect you also, in addition to what you know, you have hopes about what the 3 individuals on the panel might be, or the person selected to serve on the court. When it comes to those hopes, at least for me, I want you to know with certainty that I will relentlessly pursue excellence in my primary role of participating in the decisions of the Supreme Court. But I also want you to know that I will relentlessly pursue excellency in the secondary role of the administration, of promoting public confidence in the judiciary, that I would be an ambassador for the judicial court. I would be an ambassador for this merit selection process. I would be an ambassador for the people of Kansas, and I want you to know that I would serve in that role with joy. Thank you all for your time.
Thank you, Judge.
Thank you.
Thank you.
Well, wait till she comes back. We're scheduled to take a break, but we have a couple things pending. So how should we handle this? Do you want to talk about the voting procedure? Do you want to leave that till the end of our, so we don't get too far behind on our interviews?
I'm good with that.
As we take a break, even if we need to shorten it to stay on track.
All right.
Take up voting after the.
I think that's a good idea. And I think that's what we'll do. We'll take a break, but it'll be about a 6-minute break. Okay?
Fair enough.
Now,
We'll be live again.
All right, we are
Sure.
reconvening and we'll go get our next candidate.
Good morning.
Good morning,
Morning. Morning.
Good morning. I am delighted to introduce you all to Merill Carver Almond. Merill graduated from the University of Kansas Law School, and from there started her career here in this building as a research attorney for the Court of Appeals. She continued in appellate practice by going to the Appellate Defender Office, then to the Capital Defender Office. Then she stepped back from an advocacy role and was the training director for the Kansas Board of Indigence Defendants.
Everybody struggles with that one.
It's a tough one. She is also teaching a class at Washburn University with respect to capital defense. And she had a very long way to travel this morning from the third floor of this building, where she currently serves as general counsel to Chief Justice Marla Lukert. Welcome, Ms. Carver Almond.
Thank you.
Can you please just tell us a bit about yourself and what led you to apply for this vacancy on the court?
Sure, of course. So you guys all probably know me about as well as I know myself at this point because you've done all the prep work and I thank you for your diligence in that. So I just want to pick a few highlights there to talk about. As Ms. Cocking just said, I've spent a majority of my career doing criminal defense work and how I got into that actually, a real lodestone of my career has always been where can I go and where can I do some good? And even coming out of law school, I knew I really wanted to work on big questions. And I think one of the biggest questions in law, I think we can all probably agree, is looking at issues surrounding capital punishment. And in doing that work, another thing that drew me to it was I saw within the public defender sphere that it was a real opportunity to do truly excellent work. I think we all are probably aware that most public defenders are overworked, overloaded with cases. And in my first few years at the appellate defender office, that was one of the things I really hated about the job was you just feel like you're always in that triage mode of trying to get through this case so you can get to the next one because there's just always too much work to do. And so capital defense gave me a real opportunity to dig into bigger issues and do excellent work. And as part of that, of course, there is some advocacy work that goes with that. And just to give you an example of why that's part of the job. So in 2014, there were 4 attorneys and 1 paralegal, and we were doing almost all of the death penalty appeals in Kansas. So that was about 9 of the 10 cases at that time. And so very small staff working on what was a huge amount of work. And there was understandably some impatience at that time about how those cases weren't moving quickly enough. And so a proposal was made in the legislature to speed that up, to make it go faster. And we were looking at it from our perspective and our workload and seeing that there was just no way we could meet those deadlines and still do excellent work. And so we went to the legislature and explained that, and that bill ultimately didn't pass. But that is, you know, I feel like that's part and parcel of the job, that kind of advocacy work that goes with it. So I did some of that in that role as well. As you can imagine, that work is really heavy. And so in 2021, I was happy to have the opportunity to get to do something a little bit different and much more fun and work to build the training department at BIDS. When I started in that office, BIDS was doing about 10 hours of CLE a year for all attorneys, all staff. That was the training you got. When I left, we were up to about 160 hours a year of training, and that included training for staff, leadership training, new public defender training, capital training, the whole gamut of it. So I'm really proud of the work that we did there in building that program. And I see, I still talk to the folks in that training department. They're still good friends of mine. And every time they have a success, I feel a little piece of it because I can see the foundations and how it's sprung from what we've built. But even during that time, I really, really missed practicing law and getting to deal with legal questions and do that research and writing. So I was super excited to have the opportunity to work for Chief Justice Lukert. I've been in that role for 1.5 years, and there I focus on the court's administrative work. As you all probably know at this point, the job of a justice is, depending on who you talk to, 60-40, 50-50 cases and things that the public really thinks of is what a justice does. And then the other half is administrative work. And so my work focuses on that administrative side. I serve on several committees. I chair the AI committee as part of that work, just helping the court deal with those issues. As to why I wanted to become a judge, I didn't start my career thinking that that was what I wanted to do, but 5 or 6 years ago, I had been working in the appellate system for a long time at that point, and I started looking around and I realized that I didn't see people on the bench who had the professional experience that I had. I felt like that was really a perspective that was missing. And so going back to that lodestone of where can I do some good, I saw that as a place where my voice was needed. And judges, when you come on the bench, you take that oath to be impartial, to be fair, of course. And I think, 99.9% of the judges that I have met take that very, very much to heart and are very sincere about that. But we all bring our life experiences to the law and to our work. And so I saw that as a perspective that's missing. I also, as I learned a little bit more about what judges do, and particularly what justices do, I felt like that was a place that I could really excel. I think there are a lot of lawyers that are really good at the legal work and sort of that nerdy figuring out the cases side of it. I think there are a lot of lawyers that are good at the administrative side of being on committees and figuring out policy and things like that. I don't know that there are a lot of lawyers that can do both. I'm a lawyer that actually loves to do both. I like that mix. I like to have my days where I get to retreat into that writing cave and really do that deep work. But I also like getting out and working on policies and talking to people across the state. That's been one of the greatest parts of my job, actually, is getting to travel the state a little bit with the court and the chief and meet lots of people.
Thank you. Can you tell us, you worked for the court for a while, you've observed, what do you believe are the most important qualities for a Supreme Court justice to have, and how do you exemplify those qualities?
So I think the first one is humility. It is always a privilege to me. Sometimes it's like I'm pinching myself a little bit when the court has their administrative conferences and everyone else leaves and I get to stay and watch the court and how they work through issues of disagreement. And what I've observed in that is that everybody really comes in much more than I thought in my previous experiences with an open mind and with the willingness to be wrong and the willingness to really sit and figure out what the right answer to a question is and talk it out and debate it out. And so just watching that process, I think that that's absolutely the most important quality of a judge. And I've, been working on that definitely through a lot of my committee work, coming in and really listening to people before you talk, those kinds of things. Also being incredibly prepared on the law, being smart. I don't think you can do the kind of cases that I have done without some preparation, incredible preparation, and without being willing to dig into the law and do that work.
Let's go back just briefly to the kind of cases that you have done. As a capital appellate defender, you've zealously advocated for your clients facing the death penalty, even going so far as to argue that the death penalty violates the Kansas Constitution. And you've also publicly spoken against the death penalty in Kansas. So can you talk specifically about, if you were appointed to the court, how would you separate any personal views that you may have on the death penalty or otherwise on any other law from your duty to apply the law fairly and impartially in each case that comes before you?
Sure, absolutely. And as I said, as I started this, I think that advocacy role is part and part of being an attorney in capital cases. I don't really believe in doing things by halves, I guess. And so, to really do a good job at it, you have to do both sides. I think if you dig into my work on the death penalty, we have argued that the death penalty is unconstitutional. That is a rare argument, actually, in death penalty cases. I think people think that that's kind of all you're arguing about, is that the death penalty should go away or should not go away. But really, the much more run-of-the-mill arguments are things like, should this confession have come in or not? Is this traffic stop valid that led to, the rest of the evidence being found or not? So it is actually, I can think of maybe only once or twice that we've really straight on argued that this is a problem. And that was in the context of cases. A lot of my advocacy has also been fiscal, frankly, working in the public defender system, seeing how strapped for resources that system is and how much we pour into the death penalty. But that's a policy matter. That's not a matter that's ever going to be before a court, frankly. Practically speaking, right now, every case that I have worked on is at the habeas stage. So some of those are going to be coming back to the court. I would be recused from all of those, obviously. That's easy. The ones, I think there are 4 or 5 still that I directly touched as counsel. But then, as I said, the bar was very small. We talked back and forth a lot. I'm not sitting on any of those cases. As far as new cases that might come in, right now, we haven't had a new death sentence in Kansas since 2016. And there's not really much in the pipeline that's in danger of going that direction. So I think it's going to be a while. And my hope would be that I would have some time to establish a good track record as a fair justice, for parties to trust me, to have ruled on other issues in other cases by that time. But I think ultimately you have to go back to the judicial canons and look at the appearance of fairness. And if I felt like the parties couldn't believe that I could be fair in a case, I would recuse. That is a conflict. I know. I think everybody comes into this that's done legal work with conflicts. Mine are fairly contained, actually, to that one issue.
Thank you. I think I'll ask one more question before I open it up. You've had a front row seat here, being on Supreme Court staff for the last few years. Can you talk to us about what you believe the greatest challenge is facing the Kansas judiciary today and how you would contribute to finding potential solutions?
I think one of the greatest challenges, at least, is that public outreach piece, is people understanding what the courts do, why they do it, and especially when a decision goes a way that the public doesn't think it should go. I think that can be really hard because courts can't explain themselves other than in opinions. So I think the first thing you have to do is write very clear opinions, obviously, make them understandable for the public, so that people understand why the court's doing what it's doing. I also think, and I've seen some really great examples of this in my work on the AI committee. For example, I believe it's Arizona now, they have an AI avatar that's doing summaries, basically, of the opinions, really digestible summaries of why the court decided what it did. And they're putting those on their websites along with the opinions, things like that, just to make it, that reasoning, much more accessible to the public who may not have time to go read a 100-page opinion, frankly. I also think a lot of the outreach that the court is doing, Supreme Court on the Road, I've gotten to do 3 of those now, I think. And getting out into communities, meeting to people, talking to people, really talking particularly to young people about what the court does and why the court system works the way it does. I had a really good experience actually in Fort Scott, and I was shadowing with Justice Standridge, and she talked about how, as an attorney, She had clients, obviously, but as a justice, her client is the law. And I thought that that was such a good way to explain that. And she talked about how fun that is to be able to be the lawyer for the law, essentially. So making it easy to understand like that, I think, is really important.
Thank you. Open it up.
Questions?
Well, I'll go. So what do you think the biggest challenge to the Kansas Supreme Court is going to be in the next 5 years or so? Biggest challenge that court will face, and how would you play a role in dealing with that?
I think obviously the constitutional amendment is looming. And I think that also goes back to outreach and educating the public about the merits of the different systems. I think there is also, I think technology is a huge challenge. Keeping up with IT security is a huge part of my job now, making sure that we know what the latest and greatest is. I think AI is going to be a huge challenge. Actually, one of my subcommittees that works on that is meeting this afternoon to talk about some policies for things like deep fakes in evidence coming in, and how do we prevent things like that? What do we want attorneys to have to say before they can submit a pleading that has been used, where AI has been used to draft it, things like that. So I think that other than the public perception and outreach, which I think I just talked about, I think technology and security are going to be huge.
You mentioned, well, one, thank you for being here. You mentioned the different systems, and it made me begin to think about this process, merit selection versus selection by the people. Just curious if you would share with the commission maybe your thoughts or maybe benefits to both sides and what your preference is.
I guess I do want to be careful about that because I am a judicial branch employee at this point too. So I have to wear both hats there a little bit. Obviously, I think having a committee like this that has gone through my record very thoroughly, has talked to a ton of people who know me, who have worked with me. I think that vetting process is important, and I think that's hard to duplicate in an election. I also think that it's hard, and other people have said this, the people who are good at being politicians and good at running for elections are not necessarily the people who are good at being judges. That's sort of a different skill set. That all being said, though, I think, I don't want to pretend that direct election of justices is not a huge deal, because it is. But every judge or justice I have ever known, it's not like those retention elections are nothing. Judges and justices take those very seriously. Those are not easy days for them from what I've observed. And I think that that I don't know how much further I want to go on that.
Okay,
but-
sure. I appreciate you responding.
Sure.
You've obviously had a lot of criminal experience. Have you had any civil law experience?
So actually, a lot of what I do now is kind of more in the civil realm. It's been a lot of fun. It's actually brought, I tell people, it's brought a lot of joy back into the law for me, to go from being so incredibly specialized and really specialized in the worst of the worst to getting to be a generalist again. So every day at my job now, I, often don't know what I'm going to walk into, and that's been a delightful part of it. I've done, a little bit of HR stuff, some open records requests, obviously court rules and things like that, working through that, looking at civil issues from an access to justice perspective. I serve on the KBA's Access to Justice Committee, and usually end up pitching in with the Access to Justice crew that's here at the court when I can. I like to do that work. So I have not had a lot of civil experience, but I've definitely gotten back into that in this last period of time working for the court.
Ms. Carver, do you view your lack of experience in a more traditional civil practice to be any kind of a weakness for you?
I think obviously, probably the perfect judicial candidate might have a balance of criminal practice and civil practice and a little bit of this and a little bit of that. But also there's some deeper practice that goes along with that. And I view my practice really as an appellate specialist practice. And I think that that is a huge benefit to the court. I've seen, I taught a CLE actually for court research attorneys this past December and talked about sort of the experience as a litigant in the appellate courts and got some really great feedback on that about, I never knew that this was what it was like for someone who is a litigant in the appellate courts. So I view that as a tremendous benefit. I also think it's important to note that really about 2/3 to 3/4 of the court's docket is criminal. So having someone with deep criminal experience is important, and that's not particularly represented on our court right now. So that would be a gap that I could fill.
Do you have a philosophy with regard to constitutional interpretation?
I do. I don't know that it's one that fits neatly into a box of textualists or modernists or all the categories that that people use. I would say that my first stop when looking at a constitutional issue is to look at the text of the Constitution, and if the text is clear, I think you're done there. I think that that's pretty easy. I also think that at a certain point, as they say, Thomas Jefferson didn't have a cell phone, so you have to extrapolate a little bit from what they meant those words to mean and then apply it to a modern situation. I think you can usually find the answers in the text. And if not, you look at the history, you look at the legislative, history around the time, what people thought words meant, things like that. It's I would say textualism, but with a little bit of pragmatism thrown in there too.
Thank you.
Sure.
So you are probably, as opposed to most of the other candidates, more well acquainted with all the 6 justices who will remain on the bench. Where do you think you fit in with that group, and what do you add with the group that is now on the Supreme Court?
I think adding the experience as someone who has appeared primarily before the Kansas Supreme Court, I think that that's a valuable experience to be able to hear the perspective from a litigant side and even just really basic things like this is what litigants are told when we walk in to do an oral argument. The justices aren't there for that. They come in later. So having those conversations has been really important. I think also my deep experience as a criminal advocate, we don't really have that on the court right now. I think, the remaining justices, there's some district court judges, a little bit of civil practice there. So that deep criminal expertise is a gap that I would love to be able to fill. I also think just being able to keep pace. We have an incredibly smart court, and I'm not saying that because I know they're listening and I'm trying to suck up. We really do have an incredibly smart group of justices. And so I think just being able to keep up with that is going to be a challenge for somebody walking in. And I feel like that's a challenge that I would like to accept.
I've got just a brief one here. You touched on it, but you mentioned that you thought you could bring something to the court that it maybe doesn't have currently. And I wanted to make sure that what that was.
Sure.
And I believe it's your advocacy as a appellate public defender. Is that right?
I think so. Just that perspective and life experience.
And that also involves some substantive law, and we talked about the difference between criminal law and civil law. And so, is there anything about that you think would make it difficult for you to handle cases and apply the law to the facts of each case as it came before you at the Supreme Court?
So actually, that was a question that I was wondering how I would do with myself when I started this job 1.5 years ago. I was very sincerely entered into it thinking, I like doing the advocacy part of the law. I know I like that. what's it going to feel like to give that up and become neutral again and go back into that neutral role? And I wasn't sure, honestly, I was not sure, but it has been delightful, actually. And for that reason, I told you about justice standards, talking to the high school students. When you are advocating for a client, a lot of times the process, my process anyway, is to look at what the law is and then look at how you can spin that or argue it to make it go in favor of your client, right? As in a neutral role, you don't have to do that. You just get to figure out what the law is, and that's it. And apply it to the facts, of course. But I really do enjoy having the law as my client quite a bit.
Yeah, well, and that relates to what I was also thinking about, and that's, we want our justices and our judges, period, to all be impartial.
Of course.
Of course, when you're a lawyer, you're not impartial. You're presenting one side and you're arguing about how that side should prevail with whatever issue may be for the court. When you're the judge or the justice, you have to be impartial and not take sides until it comes time to decide the case, right?
Of course, of course. And I think some of my practice really, in some ways, I feel like my experience gives me sort of superpowers in being impartial because no one really looks at a horrific criminal case and says, I don't feel anything, right? Nobody does. And I think there's some sort of myth out there that defense attorneys can do it. Absolutely not. I have that secondary trauma, same as everybody else does. But in that role, you have to be able to compartmentalize quite a lot and set your feelings aside. And in that role, look at what's best for your client. But in the judicial role, I think look at what the law is. And so that practice is something that I've gotten really good at.
Thank you.
Thank you.
So just my very last thing is, I've spoke to a number of Kansans about you, very highly favored, and, you're fun, organized, balanced, and, you spoke to your superpowers of being impartial. One Kansan did say that you have some impartiality to large reptiles, that you love dinosaurs.
Oh gosh.
And so just want to know, is that true? Is that your?
That is definitely true. My family loves dinosaurs.
Wonderful, wonderful. Thank you for answering that.
Well, with that, are there any other questions?
Is there anything else that you wish that we would have known? So one thing I did want to talk about actually just briefly is a personal experience that's really important to me. And that is one of my favorite things that I do when I'm not a lawyer is I am a Girl Scout troop leader for my daughter's troop. So she started kindergarten, had the luck of starting kindergarten in 2020, which was a great time to start kindergarten, let me tell you what. And so our troop actually started on Zoom. And I had about 10 kindergartners on Zoom. So I felt a lot of sympathy for the teachers at that time. But our troop has grown and we get to meet in person now, and it's great. And we do a lot of things. And those girls, I have to tell you, they are a light of my life. And really, I've learned a lot through my practice of law, all the experiences I've had, but they teach me every day about getting along in a group and negotiating and staying cool in a crisis. And they keep me very humble. And so I think that's in addition to some of my legal professional accomplishments that we've talked about today. That's one personal thing that I wanted to talk about because it's very meaningful to me.
Well, I agree with you. Girl Scouting is a really good thing. Thank you. Really appreciate your time and appreciate all your comments.
Thank you. And thank you all so much for your work.
Thank you.
Thank you.
For applying. Thanks.
Think so. Maybe just.
Good morning.
Morning.
Here.
Yeah, right there. That's the hot seat.
All right.
Commissions, it's my pleasure to introduce to you Crystal Vokens. She grew up in Burlingame. I confirmed that, so I know that's truly where she grew up. She went to Washburn and received a Bachelor of Arts in Political Science. She went to Washburn again for her Juris Doctor degree. She received that in 2010. She's been a research attorney for Johnson County. She's been in private practice, and she's been involved in as an assistant professional diversity, disciplinary administrator at office. And she's currently training public defenders. So with that, I'll start and ask you, first of all, why do you want to be on the Kansas Supreme Court, and what qualities will you bring to the court?
Well, I have always had in mind that I would like to be a judge someday. So there's that. But the reason why I have applied now is I am seeing universally, not just in Kansas, but universally, I'm seeing a more negative perception of the judiciary. And I think that that is based on a lack of understanding of the judiciary and how this system is supposed to work. That's concerning to me. I'm seeing the judicial system and judges being used in partisan politics to make arguments for and against certain policies. I'm hearing references to judicial activists, which was never something that even came to my mind or that I had ever heard of before recent times. And that's deeply concerning because I have a sincere respect for the law and our judicial system. And I know how it operates. I know that the vast majority of judges, if not all, take their jobs very seriously, and they go to great lengths to be impartial. So I want to be part of showing the public that that is the case. And so how I would do that and what skills I think I bring, I think I bring an understanding that especially with today's technological age, there's an overabundance of information. And if we don't share information about how our processes work and how it's meant to work and its role in government as a whole, that void is going to be filled with other information or even misinformation. And so I bring an awareness that we really need to get ahead of that and show the public what our job is and why we're doing it well as a legal profession and as a judiciary. I also think that I bring a diverse range of legal experience. I have practiced not in every area of the law, but in a lot of areas of the law. I call it solo practitioner. I was practicing with my husband, but it was basically the same as what a solo practitioner goes through. We had to run our own business, manage our own trust account. And we practiced a lot of law that I never really expected that I would, especially early on. So my practice, after I was a research attorney working primarily on criminal cases, I got on the appointment list in Johnson County. Those judges knew that I could do those child in need of care and criminal defense cases. So I wound up practicing criminal defense, child in need of care, and then evolved later on to civil litigation. I did cases of all different kinds, involving, those cases involving voluminous discovery and the need for deep research and writing a lot of motions, and then eventually writing appellate briefs. I kind of became known for the person who likes to write and do legal research. And so some attorneys who maybe preferred not to write their own appeals would come to me and I'd work on those. So, and then eventually I got to disciplinary and I delved deep and became proficient in attorney ethics, and which from what I can tell, based on this court's docket, make up 1/5 to 1/4 of the cases they hear every oral argument session. So I think that's an important background, and that just the general diversity of the types of clients that I saw, the types of cases that I saw, will be good for me to bring to this court. Lastly, I think that my way of working with others will fit well with this court through working in the disciplinary office particularly, and as counsel to the board. I became pretty familiar with these current Supreme Court justices and kind of the types of questions that they asked during oral arguments. The orders and reports that I wrote as counsel to the board wound up being the court's orders in a lot of cases. For those disciplinary cases, they tend to put in quotes the final hearing report that the hearing panel writes, which is what counsel to the board does for the hearing panel. So I would write these reports for the hearing panels. They would review it, make sure it's what they decided. And then ultimately that gets adopted into the Supreme Court's decision quoted, and then they add their analysis at the end. So I'm pretty familiar with what they're looking for, what is important to them. And so I would come to that with that understanding, and also with an intent to develop a relationship, listen and understand, and try to reach a consensus with the other members of the court.
Thank you. So now one of many of the recommendation letters that we've received describe you as being intelligent, kind, humble, mature, and a good listener. You've already mentioned that you would listen to people. Of all those traits, which the people that know you have said that you have, which one or which ones would be the most important traits for you to have in your view as a Supreme Court justice?
Of those traits for this role, I would choose listening. And with that, I think patience, because sometimes when two people disagree on something that's important, which is a lot of what this Supreme Court decides, emotions can come into play, and that can kind of turn off our ears to hearing each other. So listening far foremost to me is the most important thing. Without listening, not much else matters. You can make the best argument, and if you have not listened to what the other person said, not only are they not going to hear your argument because they haven't felt heard, but everyone else is going to recognize that you haven't heard their argument, and maybe you're not even addressing what they think is the main issue. So I think that listening, and then along with that, understanding with an open mind. And then finally, being able to take what I have heard and to take what I understand the law to be, and for one, listen with an open mind, to know always that my mind can be changed. Sometimes I'm wrong. I am not always right. I recognize that. And so listening with an open mind, but if I listen and I understand and still believe that my interpretation is correct, then coming with my counter argument with an understanding of their points, and then maybe convincing others who might be on the fence, or reaching the points of consensus where we can, to the extent that we can, if we still continue to disagree.
So now in your current job, you're training public defenders. What is there anything about training somebody where you're like a teacher that you think will translate to the job of being a justice on the Kansas Supreme Court?
Yes. In my current role and in my immediately previous role, I get to present a lot of CLEs, continuing legal education presentations. That is my favorite part of my job. I love first learning what the people in my agency want to know more about, and that can sometimes expand me outside of my comfort zone. You know, I can easily give a presentation on attorney ethics. I feel proficient in it. I feel confident about it, but that may not be what they need in this moment. And so maybe I need to go out and learn a little bit more on a subject. I've done that in several instances in this role. I've learned about emotional intelligence in order to create a presentation on that. I've learned about different areas of criminal law that I hadn't delved as deeply into. So that experience has been so fun because it's like being a student all over again in order to teach. And then in my last role at the disciplinary administrator's office, we also provided as many free CLEs on ethics as we could, because 2 of the 12 CLE requirements for attorneys are to be in ethics. And sometimes that's hard to meet if you're not hitting the right time, and it can be expensive. So I really love giving CLEs. I would love the opportunity to continue doing it for the rest of my career.
So what we've learned, Chief Justice Looker was here and told us about kind of the job of a Supreme Court justice, how much of it did not involve hearing cases or oral argument or writing opinions. I think of 60% or more is administrative and deals with a whole lot of other things that they have as part of their job under our Constitution. So tell us about your administrative experience. You mentioned that you and your husband were in a private law firm, but just expand on that if you would.
Well, in my current role, of course, I'm part of the administrative head of the Board of Indigent Defense Services. Training is inherently administrative. So I just described a lot of what I do there, but the breadth of it is we have offices across the state of Kansas, which can present its own difficulties because each one differs in size and in needs. And so that requires a lot of coordination, a lot of follow-up, and a lot of understanding of the diversity of the people that I'm working with and the types of cases that they're facing. So administratively, it's a lot to coordinate. Before that, of course, I ran my own law practice, which entails everything that running your own business does, plus the practice of law. So I was, along with my husband, responsible for supervising administrative staff, managing our trust account, making sure our cases were organized, our files were kept well. Basically, you know, ordering toilet paper. I mean, anything that comes with running your own business fell to us. So that allowed me to see every single element that someone has to touch when they're running their own business. Then when I moved on to Sloan Law Firm, there was less of running our own business, but we recognized quickly that that law firm had a case management system that was very old and it was about to be sunset, which means the software wasn't going to be supported within the next couple of years. And they weren't really certain about what they wanted to do next with case management. So I was part of a team that researched all the different, well, not all, but the good ones that we could find, the good case management system options out there. The firm decided on one. And then the firm actually paid me extra to do the data transition from the old system, which this is a decades old firm. There were thousands and thousands and thousands of clients in their records. So it was a lot of spreadsheets, but I got their information transition. We got the trust count balances transition. And then as part of that, they also paid me to train everyone in the office, attorneys, staff, on how to use the new case management program. And that was a lot of work for me. And then in my role as counsel to the Board of Discipline, that board is made up of 20 attorneys who are volunteering their time to hear attorney discipline cases all over the state. They have their own active private practices, and they're attorneys in good standing. So automatically, you know, they're busy people. My job as the state employee, kind of coordinating, was to be respectful of that, but also make sure I'm staying on top of them, to make sure that I'm helping them keep track of what they need to be doing. when they sit on hearing panels. I set up the courtroom with IT to get ready for the hearings. I made sure everyone had lunch. I mean, every single thing I got to touch in that role. In addition to that, I advised the hearing panels on attorney ethical rules and case law that applies, as well as the procedural rules in attorney discipline cases. I sat in on their deliberations and took notes, and then I wrote their final hearing reports recommending what they found and what discipline. But that, it consisted of everything, keeping track of the record, the filings in the case. I got to be the clerk basically for them in those cases. So I've had a really broad range of types of administrative experience that I'm really excited to bring to the court. I think that technology in particular is going to be the forefront issue for everyone, including the court. Especially, when we get into artificial intelligence, that is going to change quickly and dramatically, I think, how the system operates. But I have always enjoyed and been interested in staying ahead of technological advances in the practice of law, like with case management systems. So I'm really excited to bring those skills to the court.
All right. Let me ask you this. Of all the significant cases that you've had over the course of your career, some of which you've identified in your application, which one of those, if there is one, if there's more, tell us there's more, was the most rewarding to you as a lawyer?
Of those 5 that I listed, the most rewarding one was definitely the one that involved family law. I won't name the names to keep their privacy, but that case, a man had come to me and I agreed to represent him, and he had served as basically the father to this child. I can't remember the child's age, but he was like grade school aged. He had played the role of father in this child's life from the time he was born. That child knew him as his father. They loved each other. He provided financially for this child without really knowing or believing whether this child was biologically his. But the reason that I got involved was there was a lawsuit by the estate. And I have to keep in mind, there were actually like several different cases involved, so I can't remember what happened under which case number. But I remember that the estate had sued the mother, or maybe vice versa. But basically the grandparents of a man who they believed to be the biological father of the child wanted to establish that deceased father's parental status and to get those parental rights of a father. The man had died very early in the child's life. I'm not sure if he had much exposure to the child before then, but he was no longer around. And so our argument was that my client, who had served the emotional and financial and physical role of being a father for this child's life, should be deemed the father. So we filed a motion to intervene. I researched a new area of law for me and filed a motion to not do DNA testing. And I looked up the factors at the time, the statutory factors for finding someone to be a father. And it's not just a matter of whether you have DNA that matches that is under that statute. So I filed that motion. My client was eventually established to be the father of the child because it was in the child's best interest that he be found his father. But the reason why this case was so rewarding, in addition to that, which I felt like was the right situation for both my client and the child, was I got to talk more with the grandparents' attorney and then the grandparents. And I found out, even though what they said they wanted was to get this legal status for their deceased son, what they really wanted was to just be able to continue being with the child. They loved this child. They spent time with him. He loved them. They just didn't want to lose that. And so, they thought that in order to do that, they needed to get this legal status. But in the end, after talking to my client, he said, well, yeah, it is great when there are more people in a child's life who loves them. I don't want to end this relationship with them. So they came up with an agreement, put it on the record that the grandparents will get to visit the child, you know, however often that they wanted to. And it just really made me realize that you can get to a solution that works for everyone if you just listen and take the time, put the work in.
Very good. Thank you. I'll turn it over to the rest of the group.
Other questions?
Crystal, I'm paraphrasing here, but thank you again for being here. But you mentioned if we don't share information, a void will be filled with misinformation. I'm curious if you have any ideas for outreach to the public and if you think applicable the other branches of government.
Or, I'm sorry, what was the last part?
The other branches of
The
government.
other branches?
Between the judiciary and executive and legislative.
I feel like executive and legislative may have a little more tools at their disposal because they actually run in elections. They have those opportunities to convey at least their own personal positions. The judiciary, I feel like we need to be more careful. We're working with very sensitive information. So I'll talk about that. And then if you want me to fill in more on the other branches, I will.
Oh, I just mean the relationship between all. So
Oh, between them.
both creating
Yeah.
awareness among Kansans, but also your partners in government.
Oh, thank you. Yes. Well, I think that, you know, some ideas that I have heard from others have been, you know, teaching civics more in school, more civic outreach. And I think those are wonderful things. I don't disagree with that. I think we should do it. But as a legal community, I think that we need to be aware of the situation that we find ourselves in and how the public actually gets their information now. And most people get their information through social media. And I don't even know yet how artificial intelligence is going to change the method or the type of information that's going to go out there. But I think, number one, we need to get up to speed on how that information is getting to the people and then get the accurate information out there through all of those means. Because like I said, if there's a void somewhere and that is how those people are receiving that information, they're going to receive whatever information is there where they're at. So that probably means, in practical terms, I think a very early on and basic thing, not basic, not easy at least, thing that I would do is make the Kansas courts website more accessible. I have seen there's been a lot of efforts by the court to do that in recent years, and I've really appreciated that. But even I, as an attorney, can have difficulty finding what I'm looking for on the court website, and not everything is out there and accessible to the public. For example, I know that the attorney discipline cases aren't accessible. If I wanted a disciplinary, like if I hired an attorney and I wanted to know their disciplinary history, the only thing I could find online is their licensure status, like disbarred, suspended, active. If I wanted any more information, I'd have to call an office to get that. So I think putting more information just out on the website is a great start. And then from there, you know, I'm aware that the Arizona Supreme Court has started using AI avatars to present reporting of their decisions. So I don't know all the implications yet. I'd be very careful, especially from the ethics background, of making sure that we're not sharing information that would prejudice, especially family law cases, especially children. But once I felt reassured that we could protect that, I would say let's start exploring those avenues of, you know, using AI to speed up the process of getting the information out there, so that just so that, like I said, we can make sure that the correct information is getting out there, it's accessible to the public, and the people feel like we're not acting behind closed doors. That this isn't some secret process that they're not allowed to know about, that we are working for them and that they have a right to know what's going on in the judicial branch. I hope I answered your question.
Yes, thank you.
Other questions?
Ms. Vokens,
Yes.
we've got 15 applicants. They're all clearly qualified, and that includes you. Do you have a sense of what separates you from the others to a degree that you should be one of the three that we should send to the governor?
I haven't done deep research into the other applicants, so I'm going to go based on what I know about me.
Perfect.
I think that there are three reasons. And I've talked a little bit about all of them already. But the diversity of legal experience, I think, is very important here because I found that I developed an understanding of my clients better, their types of cases, their interests, the opposing party's interests, every time I delved into a new area of the law. There are different procedures involved that can be very different from the other types. And so I think that my diverse practice would be an asset on this bench. And I'm not sure that everybody gets to experience that in their legal practice, especially at my age. I'm probably one of the younger applicants, if not the youngest. I also think that that is an asset. I would come into this role knowing that I don't know everything. And I think that judges should be continual learners, continual students of the law, because you don't just get to practice in one area of the law when you're a judge. You see every single case that comes through the courts in Kansas, judges as a whole. Of course, the Supreme Court doesn't hear all of them, but they get to see a lot of different types of areas of the law. And I think that my diverse background and the examples that I showed that I am able to, when I get that new area of the law, I can delve in and I can learn it. I can darn near become an expert in it in not too long of a time is an asset. Also, my disciplinary experience, like I said, I'm pretty, I think it's like 1/5 to 1/4 of the court's cases are those disciplinary cases. And that's part of both their case docket and also the court's administrative duty to oversee the judiciary and the bar. And so attorney licensure, attorney discipline, all of that flows up to the Supreme Court. The Supreme Court's the ultimate decision maker and authority in those cases. And my proficiency in the attorney ethics rules, my experience with the disciplinary procedures, I could see being an asset on the court. My administrative background I talked about, I don't shy away from any administrative duty. I'm somewhat known to be not afraid of the grunt work, so to say. You know, I will learn anything and there is no job too big. So that I think would be an asset on the court. They would say, hey, do you want to take on this new project? And I will say, sure, why not? Let's figure it out. And then finally, I think that I can bring a collaborative voice to the decision-making process, because I think that that comes into play with educating the public and the public perception of the courts. Not only do we need to get more information out about what we do in the legal system, but I think that the Supreme Court especially needs to present a cohesive voice to the public. That doesn't necessarily mean that all the justices should agree on everything, because that's going to be rare. But it does mean that the court is perceived as treating each other professionally, being agreeable, finding common ground when they can, and being respectful when we disagree. And so I think that I can bring my background of being a listener to that process, letting the other justices know that I respect them. I respect, and I hope to, if I were appointed to this position, that I could learn from them. Bringing that listening, that understanding, that, kind of reaching creative ways to come to agreements where we can, I think will also be a unique and valuable asset.
Thank you.
Thank you. We appreciate your time.
Thank you. I appreciate your time.
Do you have?
And right there. Got a good view. Well.
He said it's just Robin, but he's a retired captain from the Navy. He's had a 25-year. He's graduated from Case Western Reserve in 2000, started in the Navy in the JAG, has worked as a defender primarily in the JAG, is that correct?
That's true. I prosecuted, but primarily worked as a defender. That's right.
But he's had a very, mostly in the military, where he works as a public defender in the DC area, federal. And also his last 2 years in the Navy, he was an appellate judge for it's a combined Navy Marine appellate judge.
Yes,
2 years.
that's right.
And now he's working with the Department of Defense.
Yes, that's right. In the Office of General Counsel.
But living in Lawrence, Kansas.
That's right. Working remotely from Lawrence, Kansas.
Well, let me get back to my seat. Well, why are you seeking a appointment to the Kansas Supreme Court after your 25 years of experience and primarily in the military?
Well, to answer that, I need to tell you two things. The first of them is that I was first caught the bug for appellate litigation in 2004 when I was first assigned to the Navy Marine Corps Appellate Defense Division. And so being on the appellate bench has been a career aspiration of mine. I first successfully screened for the appellate bench in a process very similar to this in 2012 as part of the Navy Marine Corps screening process. I screened as a trial and an appellate judge. And as you noted, I was, my last assignment was as an appellate judge, one of 9 on the Navy Court, which is an Article I Federal Court of Appeals sitting in the Washington Navy Yard. The other thing that I need to tell you is that in 2009, a Navy buddy of mine introduced me, he's a KU law grad, introduced me to my now wife, who is a double Jayhawk, the former captain of KU's tennis team. And I'm not going to tell you that she brought up moving back to Kansas on our first date, but it wasn't long thereafter. But as you may have surmised, Kansas is no place to build or base a Navy. So we weren't really sure how we were ever going to accomplish that goal. My family, my mother's family is originally from Kansas. They live over in Lawrence. But in 2023, my wife, who works for a big law firm, was given the opportunity to work remotely. And so we were finally able to achieve coming home. And so we set that process in motion in 2023. I was able to retire. So that meant I had 8.5 more years before I faced mandatory retirement, but it meant leaving the bench, leaving the Navy, and coming back home with our family members so that you know, they could watch the many volleyball and soccer games that our daughters go to.
Okay. So I'm going to ask you the hard question. You've only been in Kansas for 2 years, is that correct?
I've been a resident of Kansas for 2 years. That's right.
2 years. Do you think the fact that you've never practiced law in Kansas and are not familiar with Kansas law put you at a disadvantage?
I don't think that it does put me at a disadvantage. I think I've been training for this experience, frankly, my entire life. I was born into a military hospital in the United Kingdom. And my father is a retired Air Force Master Sergeant. So I followed him on every assignment for his career. And then I began my own military career. And what that means is every 2 to 3 years, we were moving to Texas, to Portugal, to somewhere else, walking into new schools, walking into new environments, and having to make friends. I continued that trajectory into the Navy, where I was walking into a new country, a new legal office, new paralegals throughout my career. And I culminated that as a captain in the United States Navy, where you were not only walking into a new legal office, having to earn the respect and ultimately, hopefully, friendship of the colleagues, but you were expected to lead those individuals. I've been a leader within the Navy. I've been a leader on the Navy court, and I believe that I'm prepared to be a leader at the Kansas bar as well.
So I guess leadership is one of the attributes you think you would bring to the Kansas Supreme Court. What else? What other attributes do you think you have?
I bring a depth of legal experience. I've had the opportunity to argue 27 cases before the Court of Appeals for the Armed Forces, which is a circuit level court of criminal appeals that sits in Washington, D.C., 5-member civilian court. I've had the opportunity to argue in front of the 4th, 9th, and D.C. circuits and take 2 cases before the Supreme Court of the United States. I've been in the well of that court for both Donato and Ortiz. And so in addition to leadership, in addition to the experience that I've gained as a veteran for the past 25 years, I believe bring a depth of appellate practice and expertise to the court.
Your practice has primarily been criminal, is that correct?
It has primarily been criminal, although I would say, I think I mentioned in the papers that I did pro bono. I was given permission. As a JAG, you're not allowed to practice law without permission from the government. I did 2 habeas cases in federal court that I referenced. Those are technically civil cases.
Right.
And I would say early on in my career, I was a legal assistance attorney at Great Lakes, Illinois, which is just north of Chicago. And the Illinois bar had a program called the Expanded Legal Assistance Program, where although I'm not an Illinois lawyer, we were allowed to go into Lake County and Cook County courts and do primarily landlord-tenant issues. So I have done some civil litigation, but yes, my expertise is quite clearly in the criminal law.
So how do you think you could get up to date in Kansas civil law so that you could sit and hear cases and reach conclusions, appropriate conclusions?
I think I would do it in the same way that any lawyer tackles a new legal issue. I mean, it wouldn't be the first time that I've had to learn a new legal system. I served for a number of years at Naval Station Guantanamo Bay, which is an entirely new legal system that is neither military nor federal nor civilian nor the law of armed conflict. And so I faced those challenges before. I perform well in those situations. But I think ultimately the role of a judge is to seek justice and try to solve that with the tools that are available to us, the presentations of the parties, and then ultimately your colleagues on the bench. And that's how I would resolve issues with which I was unfamiliar.
Other questions from?
I want to demonstrate my naivety here. Are appellate military courts, do they function in very much the same fashion as Supreme Court of Kansas, or do they run in a different way?
So the court that I served on was an intermediate appellate court. So I mentioned what I would call the Supreme Court of the military, if you will, is the Court of Appeals for the Armed Forces. It's 5 civilian judges sitting in Washington, D.C.
Is it de novo or on the record?
So our court, the Navy court, is a de novo court. And we actually have a unique power in American jurisprudence. I think only Texas has a similar power, which is a fact-finding power as an appellate court. But we're an intermediate appellate court. We sit in panels of 3. We can sit en banc. In fact, the last case that I participated in February of this year was an en banc case. We did that as part of an outreach program at Boston University, obviously in Boston. So we are the intermediate level of court. A sailor or Marine who is convicted at that court can file that appeal. And then if he or she is dissatisfied with that result, they can appeal to the Court of Appeals of the Armed Forces and then ultimately to the Supreme Court of the United States. So it's an Article I federal court, and that's the operation of that in a nutshell.
Thank you.
You said you were involved in Guantanamo, and I know that you handled a couple of very public cases, the Hamdan case and the al-Nashwari case.
Yes.
Tell us a little bit about that experience.
Well, the military commissions were established in 2006 to try alleged enemy combatants at Naval Station Guantanamo Bay, so members of Al-Qaeda and the Taliban. And judge advocates were assigned both to prosecute, defend those cases, and the judiciary as well. And so those are 2 cases that I litigated at Naval Station Guantanamo Bay.
Okay. And you were defending?
I was defending.
Okay.
Design. And I would say this, that in my entire career, I was given 2 assignments that I actually asked for. One came at the very end, which was an appellate judge, and the other one was at the very beginning of my career, which was the USS Kitty Hawk. I was in uniform on September 11th, 2001, and was given the opportunity to go forward on that assignment. Every other assignment I had, whether it was prosecuting or defending a case, was something that I was directed to do by the JAG.
Well, I'm interested to know, how hard was it for you to represent a defendant that was held at Guantanamo Bay?
Well, I mean, I think that those cases are difficult, and it was difficult. You mentioned the Nashiri case, difficult to be involved in a case which involved the bombing of the USS Cole. Difficult as a sailor, in answer to your question. But lawyers are charged with defending difficult cases. And there always needs to be lawyers that defend difficult cases. I tried during that representation to keep in mind John Adams, who you may or may not know, defended the Redcoats, including Captain Preston, who participated in the Boston Massacre. And so I think that is something. We're about to have the 200th anniversary of that incident. And I think that that's something that is a time-tested and well-worn tradition of the bar, and something that I don't know that anyone asked to do, but I did it when the JAG asked me to do it.
And wouldn't it be fair to say that under our system, a defendant in a criminal case is entitled to representation, and without that, he cannot be convicted?
Absolutely.
Yes.
It's we don't make allegations, and if there's any bright spot about Guantanamo, it is that we as a country made the determination that those individuals were going to have to be tried in a court of law in accordance with the rule of law, in, like I said, the finest traditions of our country, frankly. You're not guilty simply because someone makes an accusation. That has to be proven in the time-tested method of the Sixth Amendment.
So of all your experience, can you identify the experience that you think would relate the most or the best to what your job would be as a justice of the Kansas Supreme Court?
Well, I think what would relate the most is my time on the appellate bench. In my experience, the legal piece of that was the easiest piece of it. We were also responsible as that bench to the attending and maintenance of the Navy Marine Corps bar. There's several thousand judge advocates. That means promotion boards, it means selection boards, it means judicial commissions. And I think that that experience has ideally suited me. I had the opportunity earlier this year to be listening to NPR and heard Justice Wall talk about the Rural Justice Initiative here in Kansas. And it's very similar to some of the commissions that we have in the military, whether it's sentencing parameters or case processing guidelines. And I believe that that experience for the past 2 years has ideally suited me to step into that role.
And would that be some of the administrative tasks side of the job?
Yes, and as I said, I mean, look, the legal practice is what I love. I mean, I think if you're talking to any appellate advocate, they're going to tell you that their favorite thing to do is to go in an oral argument. But really, the hard work of a case is done in the briefs, and that's the exciting part of the practice. But there's a whole another level once you're in that leadership position and on a court of appeals of trying to manage the bar, whether it's discipline issues or whatever those administrative tasks would be. And I have experience in doing that. And I believe that I could step into that role as a justice on the Supreme Court.
So the Supreme Court sees itself, I mean, it has a large administrative responsibility. We were spoken to at the beginning of our session by the Chief Justice, and she pointed out that there's a 60-40% split between hearing and working with cases and administrative work, because they supervise all the courts in Kansas. And they also see one of their roles is an outreach role in trying to make sure the public understands what the court does, who the court is, and they're traveling to different parts of the state to try to hear cases. What experience have you had in that role, that kind of administrative role?
Well, I alluded to the outreach argument that our court did in Boston in October of last year. I do believe and was pleased to see that the Kansas Supreme Court recently went to Logan, Kansas, to the Life Center to do that type of outreach argument. That's something that I'm familiar with. I had the privilege of those 27 cases that I talked to you about at the Court of Appeals for the Armed Forces. 5 of those were outreach arguments. In my papers, of the 5 most significant cases that I litigated is the Moreno case. What is not in the papers is that case was argued on the USS Ronald Reagan while she was steaming in the Pacific Ocean. So believe it or not, the Navy flew the Court of Appeals for the Armed Forces onto the deck of that carrier, and we argued it in front of 300 sailors who were in their dress whites, so that those sailors could see their justice system, that if they were going to go to captain's mast, as we call it, an administrative punishment or court-martial, that they were going to see their Supreme Court sitting there between anchors and between us. They were sitting on bomb crates with American flag bunting up there. And so I believe that that's an important thing. As Justice Brandeis said, sunlight is the best disinfectant, and bringing the court to places like Logan, Kansas is important. It's something that I have experience as both an appellate advocate and a judge in doing.
I have a question. One of the other things that Justice Luker talked to us about was the need to for the Supreme Court justices to be able to collaborate. Decision-making is all a collaborative effort at that level of the court. My impression of the military is that collaboration is not a decision-making model. Is that a fair assessment?
Yes.
My impression is correct. How would you shift from what you've trained to do, how you've operated for your entire career, into a much more collaborative model?
Well, you're right that the Navy is not a democracy. But I served on a 9-member Court of Criminal Appeals. I served with 2 other judges. In my papers, you have letters of recommendation from those 2 judges, one of whom is now the chief judge of that court. And so I have experience working with other judges. And I hope I'm not breaching judicial privilege to say we don't always agree on the resolution of a case. you know, you have an appellate decision that I wrote, and I could tell you, you know, there were disagreements over individual words in that opinion, but that's a unanimous opinion, and we work through those differences. And so I worked with 9 judges. I'm confident that I can work with the 6 justices of the Kansas Supreme Court.
Thank you.
And as your teleport in particular, are you applying the uniform code of military justice to make these decisions?
Yes, and so I mean, the military may sound exotic, but it's not like Breaker Moran or something that would be foreign or something out of the 19th century. The Uniform Code of Military Justice is a modern penal code. We have military rules of evidence, which are carbon copies of the federal rules of evidence, with the exception that the military codifies privileges. That's the only distinction. And so we are applying the UCMJ, but like any common law system, we're also applying the case law of our court, and then also our superior court and the Supreme Court of the United States, which does occasionally take military cases. And so in that respect, we're functioning as any court that you have practiced in front of in applying both the statute, Constitution, and case law in trying to achieve a just result.
That sometimes you do that on a boat and
Yes. So yes, sometimes that does happen on a boat.
Do you have a philosophy with regard to constitutional interpretation?
Yes. I believe that the goal of an appellate court is to achieve justice. And so I don't believe in abandoning or not utilizing any tool that is available. Currently reading Justice Breyer's book on reading the Constitution. And I believe that I hold a similar view that text is important, but purpose and you know, legislative intent are also important tools that can be utilized. I have found in the Uniform Code of Military Justice the legislative history of that statute to be of tremendous value in trying to make arguments to appellate courts, and then ultimately as a judge. As I mentioned, I've been an appellate judge. You have a list of opinions that I've authored, and I think that pragmatic view that I take to attempting to reach justice is what I would bring to the Kansas Supreme Court.
Thank you.
Can you tell us, what do you believe the greatest challenge is currently facing the Kansas judiciary, and how might you contribute to finding potential solutions?
Well, I alluded to the Rural Justice Initiative earlier. And I think that is a challenge. If on that interview that I mentioned, Justice Wall was explaining that there's a judge out in Western Kansas that had to retain a lawyer from Colorado. And you know, you cannot be in a situation where a criminal defendant needs a lawyer and there aren't any to be had. And so I think that initiative made some really good recommendations. But I think that's probably one of the greatest challenges that the practice of law faces here in Kansas, whether it's a civil case or criminal case, that there are places where people can't get a lawyer. And so I would endeavor to work with those recommendations. I think one of the other aspects that the state is beginning to establish veteran treatment courts, which I understand was an initiative of former Chief Justice Nuss. And so I think veterans issues is another challenge, as we now have more than 2 million veterans of the Iraq and Afghanistan wars returning home to the United States. Not always in one piece, both physically or mentally. And so I think taking care of those individuals, trying to get them the justice that they deserve is another challenge that we face here in Kansas. I mean, there are two major military installations here. One that I'm very familiar with, the up at Leavenworth, because that's where the military's prison is, including its death row, and then obviously over in Fort Riley, just south and west of Manhattan. So veterans issues would be important to me, and I think it's a challenge that that I would like to help address.
And we have an Air Force base in Wichita, so.
I understand. I understand that there's space down there, and you know, my father, who's a retired Air Force Master Sergeant, would probably remind me of that too. And certainly, if he's watching, he's going to do that when I get home.
So I've got one other thing. You received a recommendation, as some other candidates did, from the Alliance for Justice. Did you request that recommendation?
I did not.
Did they ask you to fill anything out or complete a questionnaire?
They did not.
Okay. So it was unsolicited, and
they contacted me, told me that they were going to write a recommendation, and I said,
no objection?
No,
Your Honor.
no objection.
Okay. Very good. Thank you.
And I will tell you, I've never even heard of that organization before they reached out to me. So.
Thank you for your service in the military.
Thank you.
The job of being a Supreme Court justice is a different type of public servant. Can you speak a little bit to the obligation you may feel in this role to the people of Kansas?
Yes, I think going back to my tenure as an appellate judge, I think I felt that obligation to the sailors and Marines that worked as members of our military bar. And I would take that obligation and responsibility seriously, as I did then as a Supreme Court justice. I mean, you're expected to be a leader of the bar and to tend to that garden, if you will. That's one of the most important roles that a justice can have, in addition to the substantive legal work. You know, my family, my mother's family is from Burlingame, Kansas, and so you know, I'm familiar with rural Kansas, and would like the opportunity to serve the people of Kansas, continue a career of public service on the Kansas Supreme Court.
Well, thank you.
Thank you very much.
Thank you.
Thank you.
Well, that concludes our interviews. We still have a proposed voting method, which was used previously by the commission. Have you all had a chance to review that voting method?
Yes.
Is there any concerns or questions about the procedure as it's written?
No.
Nope.
No. Do we need to approve it?
I think we need a motion to adopt it if we
Okay.
are going to use that.
Yep. Second.
All right. Yeah. Carol and Tom. Any discussion? Well, all those in favor, say aye.
Aye.
Opposed, same sign. Well, the motion passes. Okay. Well, it looks like we probably need to move into executive session. Do I have a motion?
I would move that we move into an executive meeting to discuss sensitive information contained in the personal records of the applicants, including the background checks for judicial nomination, and that the justification for recessing into executive meeting is to protect the privacy of our candidates. I also request that Doug Shima and Michelle Moore be allowed in our meeting in executive session as commission staff, and that we would reconvene in this room at 11:45, or 11:50. 11:50, 30 minutes.
50, okay. Is there a second to that motion?
Second.
Any discussion? All those in favor, say aye.
Aye.
Opposed, nay. The motion carries. So we will now adjourn to executive session.
You guys did the microphone. We're back.
I'd make a motion that we return from executive session and resume the open meeting of the commission, stating that no formal action was taken during the executive session.
Second.
Is there a second?
Second.
Second. All those, any discussion? All those in favor, say aye.
Aye.
Opposed? Motion carries. So we are now at the point where we are ready to vote. And we have adopted a voting method that states that from the list of applicants, the commissioners cast votes for up to 6 candidates. And the people receiving the top 6 votes will move to round 2. If there's a tie, then all applicants with the tie vote will advance to round 2. And we've noted that at any time, a commissioner can ask for final action by making a motion to send 3 names and list those 3 names to the governor, and there will be a vote on that motion. We will do this by handing ballots to each of the commissioners. The commissioners will check their vote, and then it will be tallied and will be announced. And the commissioner will each place their name on the ballot.
Voting.
Are the ballots ready to be collected? Okay.
I will refer to the ballots as ballot 1 through ballot 9. Ballot number 1, vote for Amy Hanley, Christopher Jram, and Larkin Walsh. In no particular order. I am going to shuffle these, by the way, so they're not in any order. Number 2, Carl Folsom, Amy Hanley, Cheryl Rios, Larkin Walsh, Kristen Wheeler, and Robert Winnell. Ballot number 3, Carl Folsom, Amy Hanley, Laura Johnson McNish, Cheryl Rios, Crystal Vokens, Robert Winnell. Ballot number 4, Carl Folsom, Amy Hanley, Christopher Jram, Anthony Rupp, Larkin Walsh, and Kristen Wheeler. Ballot number 5, Carl Folsom, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, Robert Winnell. Ballot number 6, Carl Folsom, Amy Hanley, Christopher Jram, Cheryl Rios, Larkin Walsh, Kristen Wheeler. Ballot number 7, Merill Carver Almond, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, Robert Winnell. Ballot number 8, Carl Folsom, Amy Hanley, Christopher Jram, Anthony Rupp, Larkin Walsh, Robert Winnell. And ballot number 9, Amy Hanley, Christopher Jram, Cheryl Rios, Larkin Walsh, Kristen Wheeler, and Robert Winnell. By my totals, Merill Carver Almond has 1, Carl Folsom has 6, Amy Hanley has 9, Christopher Jram has 7, Laura McNish has 1, Cheryl Rios has 4, Anthony Rupp has 2, Crystal Vokens has 1, Larkin Walsh has 8, Kristen Wheeler has 6, and Robert Winnell has 6. By my tabulations, the next 6 that will move on will be Carl Folsom, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, and Robert Winnell. That match what everybody has. Okay, we will prepare a ballot for round 2, unless there's any motions before the panel.
Any concerns? Is there a motion? Proceed.
Okay, if not, then we will not take a recess, but we will quickly prepare the ballot.
Okay.
Perfect.
Just with those 6 names for round 2.
Yeah.
You might mute your mics too, then we're off. You're off.
All right, we are now circulated the second ballot. And in round two, there are the six applicants, the top six applicants are listed. And the commissioners are to vote for 5 this time. And candidates receiving the top 5 votes and any ties will move to round 3. Again, at any time, a commissioner can make a motion for final action. Are the ballots ready to be collected?
Yes.
Again, in no particular order. Ballot number 1. Carl Folsom, Amy Hanley, Christopher Jram, Larkin Walsh, and Robert Winnell. Ballot number 2, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, Robert Winnell. Ballot number 3, Carl Folsom, Amy Hanley, Larkin Walsh, Kristen Wheeler, Robert Winnell. Ballot number 4, Amy Hanley, Christopher Jram, Kristen Wheeler, and Robert Winnell. Ballot number 5, Christopher Jram and Larkin Walsh. Ballot number 6, Carl Folsom, Amy Hanley, Christopher Jram, Larkin Walsh, and Kristen Wheeler. Ballot number 7, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, and Robert Winnell. Number 8, Amy Hanley, Christopher Jram, Larkin Walsh, and Robert Winnell. And number 9, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, and Robert Winnell. By my totals, I have Carl Folsom with 3, Amy Hanley with 8, Christopher Jram with 8, Larkin Walsh with 8, Kristen Wheeler with 6, and Robert Winnell with 7. Anybody have anything different?
No.
Those are your totals for round 2. The top 5 that would move on would be Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler, and Robert Winnell. That's the way I have it tabulated.
Round 3, you vote for 4.
Let's see. So
Is there a motion by anyone? Then we will move to round 3.
correct. Round 3, voting for 4.
So we are circulating ballots for round 3.
Are you on, Gloria?
Huh?
Did you turn your mic on?
Yes.
Oh, perfect.
From the list of the top 5 applicants, commissioners will vote for up to 4. Candidates receiving the top 4 votes will move to round 4. A motion for final action can be made at any time. Has everybody completed their voting?
Yes.
Okay.
Round 3 ballots, and again, in no particular order. Number 1, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler. Number 2, Amy Hanley, Christopher Jram, Larkin Walsh, Robert Winnell. Number 3, Amy Hanley, Christopher Jram, Larkin Walsh, Robert Winnell. Number 4, Amy Hanley, Larkin Walsh, Kristen Wheeler, Robert Winnell. Number 5, Amy Hanley, Larkin Walsh, Robert Winnell. Number 6, Amy Hanley, Christopher Jram, Larkin Walsh, Robert Winnell. Number 7, Amy Hanley, Christopher Jram, Larkin Walsh, Kristen Wheeler. Number 8, Amy Hanley, Christopher Jram, Larkin Walsh, Robert Winnell. Number 9, Christopher Jram, Larkin Walsh. But my totals, I have Amy Hanley with 8, Christopher Jram with 7, Larkin Walsh with 9, Kristen Wheeler with 3, Robert Winnell with 6. By my count, the next round will be Amy Hanley, Christopher Jram, Larkin Walsh, and Robert Winnell.
Is that
Everybody's, ever got that? All right.
Is there a motion? Hearing no motion, we'll move to round 4.
Okay, so vote, now you're voting. Wait, hold on a second, make sure we're getting 4 candidates, so we're getting rid of Round 4, voting for 3. Did you want to tell the process again on what they're voting for this time around, Gloria? I don't remember you talking.
This is round 4. And from the list of the top 4 applicants, commissioners should vote for up to 3 candidates. And the number of candidates should be reduced to 3. If there's a tie, then we will have to resolve that. Are all votes in? Done?
Round four ballots in no particular order. Ballot number one, Amy Hanley, Christopher Jram, Larkin Walsh. Ballot number two, Amy Hanley, Larkin Walsh, Robert Winnell. Ballot number three, Larkin Walsh. Ballot number four, Amy Hanley, Christopher Jram, Larkin Walsh. Ballot number five, Amy Hanley, Christopher Jram, Robert Winnell. Ballot number six, Amy Hanley, Christopher Jram, Larkin Walsh. Ballot number seven, Amy Hanley, Larkin Walsh, Robert Winnell. Number eight, Amy Hanley, Christopher Jram, Robert Winnell. And number nine, Amy Hanley, Larkin Walsh, Robert Winnell. By my count, Amy Hanley has 8, Christopher Jram has 5, Larkin Walsh has 7, and Robert Winnell has 5.
So we have a tie for the third spot. So by the rules that we have adopted, if there's a tie in determining the top 3 candidates, the commission will take a vote of all applicants in the tie vote to determine the top 3 candidates. Or still can be a motion for final action if any commissioner so chooses. Is there a motion? Then we will vote on Christopher Jram and Robert Winnell for the third spot. Is that correct?
If that's what you guys want to do.
Yes.
All right.
Yes.
So we will create a ballot for round 5, voting for one candidate, one applicant or one nominee between Christopher Jram, right, and Robert Winnell. Do I have that correct?
Yes.
Yes.
Okay. Round 5, ballots in no particular order, voting for 1. Robert Winnell. Ballot number 2, Christopher Jram. Number 3, Christopher Jram. Number 4, Christopher Jram. Number 5, Robert Winnell. Number 6, Christopher Jram. Number 7, Christopher Jram. Number 8, Robert Winnell. And number 9, Robert Winnell.
Couldn't get any closer than that.
For my tabulation, I have Christopher Jram with 5 and Robert Winnell with 4. You'll need to take a motion.
Now, do I have a motion?
Your Honor, Madam Chair, I would make a motion that the commission submit the following 3 names to the governor after our tie-breaking vote. Christopher Jram, and prior to that tie-breaking vote, Amy Hanley was approved and Larkin Walsh was approved. So those 3.
Carol. Carol.
We have a motion and a second. All those in favor indicate by saying aye.
Aye.
Any opposition? The motion is unanimous. Amy Hanlon, Christopher Jram, and Larkin Walsh will be sent, their names will be sent to the governor in that order.
Correct.
And I will say that the ballots are available for review because this is an open meeting and the ballots have the names of the voters on each ballot. If there's is there any other business for this commission?
Madam Chairman, would the comment from the public, just very briefly?
All right.
As a member of the public, I would like to very much thank the chairperson of this commission for now 8 years of excellent service. It's very rare that this commission meets at a time that is so close to the end of your service. And I got to serve with you for 3 of these, and I got to observe you on this one. And a wonderful public servant, so thank you. Thank you also to Mr. Lassiter from the public for your service.
Thank you.
Thanks, Terry.
Well, he kind of trumped me. I wanted to say thank you to all the commissioners because all of you were very diligent and did a very detailed job of looking at the candidates. And that was reflected by the reports that were made and the difficulty we had in making a decision because we had very good candidates and that's important. And I hope that every time in the future, it will be a hard decision because there are good candidates who want to be on the Kansas Supreme Court. And I know you will look forward to working with our future chairman and I wish everybody well. Is there any other business to come before the commission?
Just an adjournment.
All right, well, this will be my first and last meeting because my term expires at the end of this month on June the 30th, and I won't be coming back. So I'm going to miss you guys. We only met one time, but I'll make a motion that we adjourn.
Okay, we have a motion and a second. All in favor?
Aye. And
with that, Tom Lassiter and Gloria Farha-Flingy ride into the sunset. We are adjourned.
Hold on.